Hello, today I'll be providing some training on testimony. First, we'll go over the three phases of testimony. The first phase of testimony involves displaying the qualifications of the expert to be able to render their opinion during testimony. This consists of determining the witness's testimony and addressing any issues that may be arisen during examination. The content includes the attorney who called the witness. They may ask some additional questions for clarification and to determine qualification. The second phase is direct examination. This consists of the attorney who called the witness asking open-ended questions to receive information that supports their case. This includes the background information about the expert. This includes any information, including facts, observations, and of course the opinion and conclusion of that expert. The last and final phase is cross-examination. This consists of the opposing attorney asking questions, open or closed-ended questions that help to test the credibility of the witness, clarifies or contradicts any previous statements from the expert witness, or introduces new facts or evidence to the case and highlights bias and motivations. It's essentially important to note that the specific content and duration of each phase can vary depending on the case or the complexity of the case, and the nature of the witness's testimony and the specific strategies of the attorneys involved might also vary. Next, we'll discuss the recommendations on how to prepare for a case when you receive and do not receive communication from the attorney before the trial. When you do receive communication from the attorney before the trial, it's important that there is communication on both sides. So the expert and the attorney is responsible for reaching out to each other. It is the responsibility of both sides, the expert, to translate any technical terminology and concepts to the attorney, but it's also the responsibility of the attorney to translate any legal vocabulary to the expert. A clear understanding of objectives and goals should be expressed to the counsel and should be expressed to the expert to help direct the focus. And the development of working hypothesis should also be discussed. When there is no communication between the attorney, it is important to consider the specific topic and the report. And it's also important to understand and illustrate the facts of the case to maximize effectiveness. It is also important that you have a good understanding of the results and that it'll be able to reach the intended audiences. If you are not able to explain the results of your case to anybody and they're not able to understand it, then it is important to try to rework your testimony. Next, we'll talk about identifying reasons why an attorney can object to questions by the opposing attorney. There are various reasons why someone may object to a question. The rules of evidence provided within the court proceedings does sometimes vary and is to the discretion of the judge, but an attorney may make objections when they believe that the other attorney or that a witness has overstepped specific bounds or has displayed some type of inappropriate behavior. An attorney can object to questions asked by the opposing counsel for 7 reasons. It's primarily to protect their client's rights and to ensure a fair trial. Some of these reasons include relevance. This means that the question may not have been relevant to the case at hand. It may have been too broad, too narrow, or simply unrelated to the issues being tried in the specific case. Leading question is also a reason why an attorney may object. A leading question suggests that the answer that the attorney wants the witness to give. This creates some bias in the witness testimony and can possibly direct the witness away from concepts in relation to the case. Compound questions. A compound question asks multiple questions, which can be confusing and also mislead or misdirect the topic of the case. It can make it difficult for the witness to answer the question accurately. If the opposing attorney becomes argumentative or presents argumentative questions and is not seeking information, but rather to make a statement or argument or to derive emotions for that witness, that could be objected. Also, if the attorney asked and answered questions, uh, if the question has already been asked and answered, and the opposing attorney attempts to repeat the question to get a different answer, that can also be objected. It's important to note that whether an objection is sustained or overruled specifically depends on the circumstances of the case, and is subject to change depending on the attorney, the question, or the judge. Now we'll go into how to identify compound and leading questions. A compound question consists of multiple questions within a single question. It makes it difficult to answer each question separately. A compound question will likely cause an objection, as mentioned before, because the witness may be unable to answer the question. While a leading question is a phrase in a way that suggests a specific answer. Leading questions guide a specific response from the expert or from the witness through biased language or wording. A compound question asks a lot all at once, while a leading question steers a specific answer. One should look at words like and or to connect two questions in a sentence to identify compound questions. An example of this is, did you drive the victim to their house, or did the victim drive themselves home? When identifying leading questions, look at the phrase that implies specific answers. Leading questions will also include desired responses in the question. An example of this, you were seen at the victim's house, weren't you? Now we'll talk about how I'll talk about how to enhance the testimony of a forensic expert during direct examination. Direct examination. Direct examination is offered to provide evidence in support of facts that will satisfy or refute one or more required elements of an attorney's case. The ability to coordinate verbal testimony and documentation enhances an expert's direct examination by building credibility. The ability to reference various documents, reports, and data increases the credibility of a scientist as well. The use of various visual aids such as charts, graphs can help to draw the attention of the jury. It is also important that an expert come across with a serious and pleasant demeanor and maintains professionalism while maintaining the facts. A confident demeanor can also inspire trust in an expert ability, and a pleasant demeanor makes an expert more approachable and likable to a jury. It is also important to sustain a serious demeanor to convey an objectivity and to remain impartial. Next, we'll discuss and identify and explain the goals of the opposing counsel for cross-examination. First, the opposing counsel will attempt to lay foundation. Laying foundation is a legal term that refers to the process of establishing the admissibility of evidence in the court. It involves asking a series of questions to a witness to demonstrate the evidence is not only relevant but reliable and is also authentic. Another goal of an opposing counsel doing cross-examination is to determine their techniques. The techniques of the attorneys typically that the attorneys typically employ during cross-examination of an expert. They're not specifically addressed, but they are considered. Another um, goal of the opposing counsel is making the expert their witness. This means that the opposing counsel, even if the expert witness is not someone, since it's not someone that they call, they'll highlight evidence that is favorable to their theory and make that expert their witness. Another goal is attacking the expert field of expertise. They'll attack their expertise to try to show that the expert is not credible and is not scientific or professional. They may ask questions such as, is it true that the lab you are currently working in has been cited for the use of improper procedure, which invalidates or creates some doubt in the competence of that expert? Attacking the expert qualification is also a goal of the opposing counsel. An attack on the expert qualification can cover many aspects of the resume of that expert. They may attempt to discredit certifications or degrees of that expert to create some doubt in the jury. Attacking the factual basis of the expert's conclusion is also a goal, in an effort to attack the factual basis of the testimony of the expert. The expert may attempt to show various things, such as that an expert is not familiar with the events of the case, or that the expert is unable to answer specific questions. They may also use hypotheticals during cross examinations by inserting hypothetical facts that could lead to the conclusion of an opposite, leading the expert to draw an opposite conclusion from the one during direct examination. And they may also attempt to attack the expert's conclusion. A direct attack on the position of the expert might be taken by the attorney as an effort to try to discredit them. Or the last thing we'll discuss is how to reduce vulnerability during cross-examination. There are various aspects of testimony that experts may have weaknesses in relation to, such as public speaking, that attorneys might attempt to exploit during cross-examination. The judgment of the expert can easily be exploited if the basis of their conclusion is not established or well established. And when subjective judgment and opinions are the basis for the opinion, it does create some vulnerability. To reduce this vulnerability, it's important to stay focused and maintain focus on the question and avoid getting sidetracked or veering from the focus of the testimony. It's important to be honest and direct, to avoid evasive and misleading responses, or to come up with responses that derive from the facts. It's important to avoid speculating or making assumptions, base answers on evidence and not specifically on expertise. It's important to understand the rules of the evidence and be aware of those rules and object to improper questions. It's important to practice active listening so that you can provide effective responses to questions. It's also important to maintain composure, to remain calm and collected even under pressure, as during cross examination, attorneys may attempt to derive some type of negative emotion. And it's important to consult with attorneys if you are unsure about any questions that may be asked, or you may be unsure about the proceedings within trial and during testimony. Thank you.